Hi there again. Hi, Felicity. How are you doing?
Hello, Eugene. I'm absolutely fantastic. How are you?
Always good, always good. Felicity, a question that pops up so many times, and and I have so many cases of those are maintenance cases that just drags on forever. It takes, on average, about 9 months to have that completed. What has your experience been?
Yeah, 9 months is actually short for most cases, and that's there's a very small percentage of cases that are resolved within the first appearance. I wish we had stats on this, but yeah, the first applications are for me normally resolved on the second or third court appearance. That's if the person actually, the biggest problem seems to be one, that people are not arriving at the first thing, either because they just don't, or documents weren't served. The other reason is that they don't bring the right documents to court. So these things lead to postponements.
Yeah.
And arrears is a completely different story. You know, arrears can take years.
And you would also find that that differs from court to court, because some courts are just more efficient than other courts.
I think most of them are not. There's little pockets of excellence, but I think most of them are not. And you know, I'm not blaming maintenance officers per se. I'm blaming the restrictions, the difficulties that they have. You know, absentee. If you've only got one maintenance officer, they're also human. You know, they get sick. They have deaths in their families, and you know, so if the one and only maintenance officer is not there, of course it's going to cause a delay. But you know, how do we get around that? Look, it's lack of resources. Unfortunately, those kind of things are beyond our control. As a collective, we need to really, but we know that every single government department has huge financial restrictions and constraints. So how do we operate more effectively within the limitations that we have is by people doing their jobs properly. And that is, you know, one of the things is, like, for me, if the documents have not been served, is it that difficult for them to contact the applicant and say, we are going to postpone because, you know, it's come to our attention that the return of service is not here. So instead of wasting your time, we are going to postpone it for 30 days.
Yeah.
And we're going to make sure that that service is done.
What very little people know is that is section 16(1) of the Maintenance Act, where it says that a court can make an interim or temporary maintenance order where there's no maintenance order in force, and where a postponement was absolutely necessary, and it was established that it is absolutely necessary for them, and that hardship may be suffered. And we find that in each and every case, hardship will be suffered if a case is being remanded. So why would the maintenance officer not enforce section 16(1) where they can actually ask for an interim maintenance order? What do you think? What would be the reason for that?
Well, I mean, those are the few cases where the person actually arrives at court. You know, if they don't bring the necessary documents, then for me, yes, there's accountability to that, and there's a consequence. So yes, we are going to, we can, the legislation is there. But why they're not doing it? One, I don't think they really know the Maintenance Act. They don't know about the interim order or their interpretation, or they've been instructed not to do that. Because again, it's interpretation. What is hardship? So hardship for one might be, well, hardship is the normal. So this is not going to cause additional hardship because that's normal. So that's an interpretation. Does it mean we need to take existing harm into account? No, because it talks about, like, the impact of this decision not being made. So, but I think if you interpret it, here is a person, there's compelling evidence. If the other person is not contributing, of course there's hardship, there's economic hardship, there's economic inequality. Just you know, and that's not even like common sense or logic. But if one person is bearing the brunt, and even more so if that person is unemployed and the person who is meant to pay is employed, I mean, it's a no-brainer. You don't need to be a rocket scientist to work that out.
Yeah. And well, I'm alluding to that now with where you said that hardship actually could indicate financial hardship, or mostly in most cases it is financial hardship, because they come to court asking for maintenance as a way of the father to support his biological child. But now they suffer hardship as a result thereof. They might have lost the accommodation. They don't have money for transport. They can't send people or the children to school as a result of non-payment of maintenance.
Okay, but for me, this is just ridiculous, because the Maintenance Act and the Children's Act and the Bill of Rights says that the child has a right to financial support from both parents and to protect the child. And, with all of this like really, all these additional inclusions in the Maintenance Act, for me, forgets that this is a requirement. This is an obligation. This is a legal obligation as well as a moral obligation. And if you have not voluntarily been doing that up to this point, well, it shows that you are that you're not willing to take responsibility in spite of all of this stuff. So it needs to be resolved. Not giving due consideration always to the person who's not wanting to pay, because that's the problem is, oh, well, he didn't get notice. He refused to sign. He's in between jobs, or shame, he's unemployed. It's always, the emphasis is always on the person who knows they have an obligation to do it. And there's too much pandering to that. Obviously, the child needs all of those, needs education, needs shelter, needs food, and if you're not contributing, there is hardship.
And obviously, because, I mean, there's a common law duty of support on the father. If he has a biological offspring, then he is liable to pay maintenance, and the maintenance courts are just the enforcement tool. We have this common perception nowadays that we have in court, where people stand in line. We are so accustomed to standing in line. If it's not for a SAP grant, it's for a COVID grant or for whatever it might be. So we have this perception of you standing in a queue and standing with begging hands, what, I want something. Isn't it time that we should change the whole culture to say, but you know what, we don't use the maintenance courts as a form of punishment. It is just there. We use the courts to enforce the common law duty of the father to pay maintenance. So we need the court's intervention to actually see to it that the father pays maintenance.
Absolutely. For me, it's a no-brainer. This is the child, and if the child is 6 years old and the father has not contributed, this is the other aspect that really just irritates me. It's because they have a duty to support from the time of birth. And we know that mothers can claim laying-in costs through the maintenance courts. Why they're being diverted to the small claims court, God alone knows, because I don't, because that provision is in the Maintenance Act. So why are these orders not made retrospectively? Because it says they have a duty to support from the birth. And if they've not, then it's them who've been avoiding. Look, I mean, if the father doesn't know that he fathered a child, and suddenly he's told when the child is 6 years old, that is a different, and I think social services really need to get involved to understand why. But these things should be made retrospectively, because there's just all of these allowances when the act is pretty clear, in my opinion.
Of course. I mean, the wording of the act is quite clear when it comes to specifically laying in costs, that you can claim from date of birth. You can claim all the laying in expenses, all the expenses incurred in connection or relation to the child. You are allowed to claim that. Most of the maintenance officers do not entertain that. They just work with the whole scenario of, this is the first application and it's from date of application going from there forward. And that's wrong. They can actually insist on laying in costs from date of.
And this is, again, I'm going to speak to the behavior and the abusive behavior and how money is used as a form of control. Because we often see in these cases, yes, the father acknowledges paternity. He has offered support when the child, if they're still in relationship, or even if they're not in relationship anymore at the birth of the child. They bring food, they bring nappies, they bring formula, whatever. They are contributing. And then suddenly he gets into a new relationship, or or she gets into, or they have a fight about something, and he withdraws that. Okay, so we also
As
know
a
that
form
the
of
main
punishment, of course. As a form of punishment.
Exactly. And the Maintenance Act is very clear that even a verbal agreement is an agreement of sorts, and
Yeah.
it can be enforced. So you can prove that there was a history of contribution. So again, I'm going to say, we need to understand this behavior, because the Act says you can claim from date of birth. And when you had to contribute at some stage, so one, there was an acknowledgement of paternity. Two, there was, morally you were doing what you felt was right to do. What changed?
Sure, yeah. Coming back to the pockets of excellence that you said, Akarat, surely there's in my experience, some courts are just more efficient because probably they have more resources or more will from the side of the maintenance officer to help those people. We know that some courts are quite troublesome and they are just being bombarded. It should be so demotivating for a maintenance officer pitching up at work at 8 o'clock in the morning, and you already have 60 people standing in a queue waiting for you, doing the same thing over and over again. Shouldn't we be a little bit more compassionate towards the maintenance officers?
Well, that's what, I've mentioned that, it's not that they are always incompetent or inefficient. I know I've been into one court, and I went to the maintenance officer and said, please, just what are your challenges? It was a specific case that I was supporting a woman. And I said, what are your challenges? Because I acknowledge that you are also having to work under very difficult circumstances. And this specific case was a garnishee order was sent to SAP's head office, okay, or to the HR department. And the person with his very unique, specific email address had left the services. So all of these emails were lying in cyberspace. This person had left, whether they'd been transferred to another, whatever. Anyway, he was no longer in that position. So I said, okay, so why is there not an automatic response to the person saying this person is no longer employed? Then the court knows that they need to find an alternative email address. Or on SAP's side, communicate to SAPs that this is coming up, and SAPs have put a forwarding email onto the person who's left. I mean, for me, these are logical things. So, I said, okay, so how do we change this? I mean, because this is not your fault. I mean, how are you supposed to know the person is not there? That is the email address that you've been given. So we can see there's lots of complexities, but he is the face. He's the person that the applicant sees and shouts at and thinks is incompetent. And it's not for him to explain all the internal challenges. But okay, so here's a pattern. This is a challenge that's come to our notice. How do we resolve this, not just for this court, but for SAPs, for example? Let's give this feedback to SAPs so that they can rectify these problems. So another court in a Boomspruit or Mpumalanga or wherever doesn't have the same challenges. Because you can imagine how many times this has happened with garnishee orders. The applicant is sitting there thinking, oh, I'm going to get my garnishee order, completely oblivious to all the gaps and failures within multiple systems. So let's have these conversations,
And I think it's a very valid point that you raise, because apart from the maintenance officer doing their work, and you have the maintenance investigator, you also have the maintenance clerk, which is in the whole hierarchy of the maintenance court. Surely there should be a follow-up responsibility on their side, because I see that very, very, very often that there's no follow-up, and that frustrates people. There's no follow-up on the maintenance investigator on the banks, for example, to say, but you know what, I've sent you an email, I've sent you a directive, I've sent you a court order that needs to be enforced. I need to get the banking details of the father, and they simply don't do that. And once they get to court, then they just say, but sorry, you know what, we haven't had the opportunity to go back and to ask them where is the documents. So there's, it seems like that there's a big follow-up or follow-through procedure that also needs to be addressed in the maintenance system.
Exactly. So as a result of that specific incident that I mentioned, there was a very attentive, progressive person from the judiciary who said, okay, so this is a problem now that has been brought to our attention. So how are we going to remedy it? Okay, so we're going to put a register in place. So when garnishee orders are made or emolument orders are made, here is a register. You will fill it in this register, and you will follow up. I can't remember what the recommendation was, but there was a system put in place as a result of that specific interaction, and there was a register instituted, and there was a follow-up. So follow up in a week's time or a month's time to see if these have been received and if they're going to be implemented. So
nothing stops the applicant from asking the court or the personnel at court, you know what, how far are you in the process, to keep them on the edge and to have that accountability. Yes. They have the opportunity. They can do that, and they can follow up on their own cases.
Yes, they can. But we also know that they're going like, they're just taking up another seat and they're just like duplicating work. We need to shift this again, the responsibility back onto the people who are mandated to do to fix the system or to make sure that the system works. We can hold them accountable by checking up, but that's our resources. You can't phone them, so you've got to physically go there. That's during business hours. That's more time off work. Let's acknowledge all of this and go, okay, let's be progressive. Let's be proactive. This is a problem in the courts. We're highlighting, we're annoyed with them, we're highlighting them. Let's work together with the people that are mandated and say, how can we resolve it? Like, for me, it's logical, and also, so we've managed to do that in this province. So how do let's make this aware, let's get other provinces to do the same thing.
Sure. Thanks, Felicity. Definitely a topic for next conversation would be the accountability of the maintenance personnel. Thank you so much for your time. We'll speak again.
Thank you, Eugene. It was a pleasure.
Bye.